Hey, welcome to The Explainer. You know that feeling, right? An unknown number calls and your stomach just drops. You just know it's a debt collector. It is so stressful. But what if you had a clear playbook for exactly what to do? Well, that's exactly what we're going to build today.
All right, so let's get right into it. The phone rings, someone on the other end says you owe money. Now, your first instinct might be to panic, or maybe even to just pay it to make it go away. But that is not your first move. Your first move is to understand the rules of the game. And believe me, there are definitely rules.
And this, right here, is your rule book. It's called the Fair Debt Collection Practices Act, or FDCPA for short. Think of this federal law as your shield. It was put in place all the way back in 1977 for one reason: to stop abusive, predatory collection tactics. And trust me, knowing what's in this thing is the absolute key to taking back control.
Okay, so first things first. We need to figure out who's actually playing this game and what the boundaries are. Because while the FDCPA is super powerful, it's also really specific about who it covers and who it doesn't.
So here's the most important thing to get right off the bat. This law only protects you for personal debts, consumer debt. We're talking about credit card bills, car loans, medical bills, student loans, basically the stuff of everyday life. But if it's a debt from your business, nope, the FDCPA doesn't apply. It's that simple.
And this next part is a really critical distinction the law makes. It's all about who actually counts as a debt collector. See, the FDCPA, it generally applies to third-party agencies. Those companies whose entire business is collecting debts for other companies. It usually does not apply to the original creditor, like, say, your credit card company, when they're trying to collect the debt themselves. This is a huge point to remember.
All right, so we know who's on the field. Now let's get to the good stuff. Your rights. This is where the power really starts to shift back into your hands. The law is super clear about what collectors must do, and maybe even more importantly, what they absolutely positively cannot do.
Okay, listen up, because this is huge. Within 5 days of their first contact with you, a collector is legally required. They must send you something called validation information. This is not a suggestion, it's the law. They have to tell you their name, the name of the creditor they think you owe, and a full itemized breakdown of the amount. Think of this notice as your first official tool in your toolkit.
And get this, the law even limits how often they can blow up your phone. The rule is super simple: no more than 7 calls in a 7-day period for one particular debt. That is a hard and fast limit, and it's there specifically to stop them from harassing you.
Yeah, and they can't be calling you at some ridiculous hour either. No 3 a.m. wake-up calls. The FDCPA sets a really strict window. They can only call between 8 in the morning and 9 at night, your local time. Anything outside of that window, that's a violation, plain and simple.
And this is where you see the real teeth of the law. There's a whole list of things they absolutely cannot do. They can't harass you with threats or use profane language. They can't lie about how much you owe or who they are. No, they can't pretend to be a lawyer if they're not. And this is a big one. They can't threaten you with arrest. That is a giant red flag. And they can't just invent extra fees or interest that weren't in your original contract. No way.
Okay, so now you know your rights, but knowledge is one thing, action is another. So let's turn that knowledge into a concrete plan. This is how you stop playing defense and start taking control of the entire conversation.
Pay attention, because this is probably the single most powerful move you can make. You have a 30-day window from when they first contact you to send them a written letter disputing the debt. I'm going to say that again. Write it, don't call. And the most critical part? Send it by certified mail with a return receipt. Why? Because that gives you cold, hard, undeniable proof that they got your letter.
And you don't need to hire a lawyer or write some fancy legal document. A simple, direct sentence like this is all it takes. Seriously, pursuant to the FDCPA, I dispute this debt and demand verification. That's it. That one sentence officially invokes your legal rights and puts the ball right back in their court. The burden of proof is now on them, not you. And check this out. The effect is immediate. The second they get that letter, the law says they have to slam on the brakes. All collection efforts must stop. No more calls, no more letters, nothing. They are not allowed to contact you again until they mail you written verification of the debt, like a copy of the original bill.
So, we've talked about legitimate collectors who might bend the rules. But you also have to be on the lookout for something else: outright scammers and fake collectors. And we also need to tackle the super tricky topic of really old debts.
You got to keep your eyes peeled for these red flags.
If they're pressuring you to pay right now, immediately over the phone, that's a classic scam tactic. If they refuse to mail you that written validation of the debt, just hang up. If they're being super vague and can't give you specific details about the account, sketchy. And here's a wild but true example. One scammer tried to create a fake deadline by saying it was April 31st, a date that, doesn't exist. And please remember this, always get any settlement offer in writing before you even think about paying.
Now, this is a question we get all the time. What about a really old debt? Something from like 7, 8, even 10 years ago. Well, there's something called a statute of limitations, which is basically a legal deadline for how long they have to sue you. Once that deadline passes, the debt is called time-barred. So the big question is, can they still sue you for it?
The answer is a big, fat, resounding no. It is flat out illegal for a debt collector to sue you for a time-barred debt. And get this, it's also illegal for them to even threaten to sue you for it. If they try either of those things, that is a crystal clear violation of the FDCPA.
But, and this is a huge but, beware of this trap. In a lot of states, if you make even a tiny payment on that old debt, what they might call a good faith payment, you can accidentally reset the clock on the whole thing. You literally bring that dead debt back to life, and suddenly they can legally sue you again for the entire amount. You have to be so careful with this.
Okay, let's talk about the scariest scenario of all. You actually get served with a lawsuit. I get it, that's incredibly intimidating. But what you do next is actually pretty simple, and it is absolutely critical. There is one thing you must never, ever do.
Whatever you do, do not ignore it. Seriously, burying your head in the sand and hoping it goes away is the single worst thing you can do. Because if you ignore it, they win, automatically. You have to respond to the lawsuit by the deadline on the papers.
And just look at the difference here. It couldn't be more clear. If you respond, you make them do their job. You force them to prove their entire case, that you actually owe the money, that the amount is correct, that they even own the debt. But if you ignore it, they get what's called a default judgment. And with that, they can potentially garnish your wages, take money straight out of your bank account, and slam a judgment onto your credit report. The stakes are just incredibly high.
So, if a collector breaks any of these rules we've talked about, don't just get angry, get even. Report them. You can file a complaint with your state attorney general's office, the Federal Trade Commission, the FTC, and the Consumer Financial Protection Bureau, or CFPB. When you report them, you're not just helping yourself. You're helping federal agencies build cases against these bad actors and protect everyone else too. So look, the next time that unknown number rings, things are different. You're not just a passive target anymore, you are prepared. You know the rules, you have the playbook, and you have the power to protect yourself. The question completely changes. It's no longer, oh no, what can they do to me? It's okay, what's my next move? Thanks for joining us on The Explainer.